welcome you to the countdown. 18 days until the general strike against Congress, where we the people have the opportunity to challenge the status quo and to say Congress, demand Congress act before the election in order to earn our votes. Before I get started with the meeting, I'd like to recite the preamble for the United States Constitution to remind us as Americans of our duties and responsibilities. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. And with that, so my name is Brian. I'm the organizer, founder of the American Union. The American Union is not a third party. It is a union of swing voters. And on October 15th, we're calling for a general strike against Congress to demand in all 470 congressional races that the candidates for Congress support immediate passage of the Blueprint for a Better America. This is a crowdsourced legislative package that we've been working on all year, and it does three main things. It will end poverty, end mass incarceration, and end the endless wars. These are issues that are broadly popular among Americans, and so the American Union, the model of unionizing as voters is a different model for changing the way that government works. And so the deal for Congress is they will have 10 days to put this legislative package on the president's desk in exchange for the endorsement of the American Union. We are a union of swing voters, and as a national union, there are many congressional races that are gerrymandered that are not competitive, but by having one national set of demands, we have the ability for just a small percentage of voters to flip the outcome between Republicans and Democrats, between incumbents and challengers, in a number of races around the country, dozens and dozens of them, that will ultimately determine the balance of power in Washington, D.C. after the midterm elections. And so with that leverage, we demand that Congress enact the Blueprint for a Better America that bring America together to end poverty, end mass incarceration, and end the endless wars. And those 5 duties in the preamble, our first duty is to establish justice. And the legislative package is broken down into sections based on those 5 duties, the first of which is establish justice. And tonight is the third section of the George Floyd Justice Act. Before we ask Americans to come together and pool their votes in demanding immediate passage of this legislation, it's only fair to explain what exactly is in this legislative package. The 50-some policies spread out across 104 sections and hundreds of pages of legislation. And so we're breaking this down every evening. And tonight, we're going to start with section 100. We're going to cover sections 120 through 132. So let's start with the first one. 120 deals with civil asset forfeiture. Now, civil asset forfeiture, if you're not familiar, is the process where law enforcement agencies, they can take property, usually cash or cars or things like that, they say is connected with a crime, but they don't actually have to charge anyone with a crime. And then billions and billions of dollars get seized, and the burden of proof is on the owner of the property to prove that they should get it back. In 2014, it was reported that all the burglaries across the entire United States had totaled $3.5 billion. But the amount of money seized through civil asset forfeiture was $5 billion. And so we can see that this is a very profitable, can be a very profitable thing for law enforcement. And that profit motive is incompatible with our duty to establish justice. Some of the cases here in North Carolina, the Department of Justice back in 2014, they seized $107,000 from a guy named Lyndon McClellan. He was a convenience store owner, and he would often deposit cash. And so the Department of Justice said, well, this looks suspicious. We're just going to seize your money. But he was lucky. He got it back a year later and they dropped the case and got his money back. Not everyone is quite as lucky. That same year, the police seized thousands of dollars from a man who had just won in the lottery. And he showed them there's receipts, say this is where the money came from, but they took his money anyway. And finally, after a year, again, not being charged with a crime, they agreed to give him most of his money back. They offered him a deal. We'll give you most of your money back. And so what do you do in that situation, right? When you're being extorted and say, look, we took your stuff, we'll give most of it back. Because if you continue to fight in court, the judicial system often often produces an outcome in favor of the party that has the most resources. And that is almost always the government. So what do? You take a deal. These days, kind of your best hope is to try and win in the court of public opinion. You can, you can draw public attention, or maybe on Twitter or social media, to the kind of outrageous behavior of civil asset forfeiture, and hope that that inspires some sort of justice for you. But you never know. Justice might not be done. And so as part of our duty to establish justice, we need to reevaluate this process of civil asset forfeiture. A couple other things. Like most laws on the books, this one is colorblind on its face, but it doesn't always work out that way in the real world. There was a 2015 study in Pennsylvania by the ACLU, and they found that 63% of Philadelphia's cash forfeitures each year involved money taken from Black residents, who only made up 43% of the city's population. And 71% of those seizures had cash forfeited without anyone being convicted of a crime. In South Carolina, an investigation determined that Black men represented 65% of all citizens targeted for civil forfeitures, despite the fact that Black men only made up 13% of the state's population. They found that white people were twice as likely to get their money back. Again, the law is colorblind on its face, but like so many policies, it is not, it doesn't actually impact the population in a race neutral way. And again, the American Union is part of a moral crusade to address Martin Luther King's triple evils of poverty, racism, and militarism. And the racial bias in the criminal justice system needs to be addressed. And so addressing civil asset forfeiture is one of the ways that we do that. So let's see, where are we at? There's the profit motive for civil asset forfeiture. And even if you win, right, even if you get your money back, there are still large amounts of harm that can be caused by having the police seize your money. There was a case in 2012 where a 35-year-old Black man named Mandrell Stewart, he was driving with his girlfriend. The police pulled him over, searched, and they found 1/100th of a gram of marijuana and $17,000 in cash. Stewart explained, yeah, I'm going to buy supplies for my restaurant. That's why I have this money. And the police still handcuffed him, took him to the station, never charged him with a crime, but kept the $17,000. And it took him 14 months and a lawsuit to get it back. But it was too late. He had lost his restaurant to suddenly have all that cash, all that capital seized and taken away from him. It cost him his restaurant. So the Section 120 will end the process of federal civil asset forfeiture. Let me go ahead and share my screen here, and we can take a look at what this law actually would do. This legislation is largely based on on HR 8997, which was a bill that was introduced by former Congressman Justin Amash in December 2020 to end civil asset forfeiture. And so that chapter of the law, take a look at that real quick. That chapter of the law is chapter 46 of Chapter 46 of United States Title 18, Title 1896 Code. And so we've got the civil asset forfeiture, criminal asset forfeiture, and then a whole bunch of other civil asset forfeiture stuff. And so what this legislative package will do is repeal and reenact that first chapter, first section, 981. So it will be short and to the point. No person shall be required under the laws of the United States to forfeit to the United States any property, real or personal, pursuant to a civil forfeiture proceeding, including a non-judicial civil forfeiture proceeding. So let's take this off the table. Section 982 dealt with criminal asset forfeiture. That's still a thing because in criminal proceedings, there are, there's due process and so on and so forth. So that section would stay, but the remaining sections 983 to 987 would be repealed. And this would be effective at the end of October of this year. And that's what section 120 would do. When we talk about civil asset forfeiture, people often complain that it's a violation of the Constitution. The Constitution says, no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. And so how is it possible that civil asset forfeiture can exist? And the answer is, well, there is due process of law. Congress wrote a law that says it's okay to seize people's property. And okay, if that's due process, then we can repeal that law. We can change that law so that the law says clearly you cannot deprive a person of their property without real due process, without a burden of proof being on the government that the person has committed a crime, that the property in question, you can't just do it on a say so, and you can't do it as part of the encouraging this profit motive. So that's what section 120 does. And let me just check the live stream here real quick to see if there's any questions. And if not, we will move on to section 121. Okay, seeing no questions. Section 121 is restricting state civil asset forfeiture. And now, so this is sort of the issue where this is a federal legislative package. And so it's sort of restricted in what it can tell the states to do. And so section 121 is limited in how we can tell the states not to use civil asset forfeiture, which is why it's titled restricting state civil asset forfeiture. And there's a number of findings. Again, these are largely taken from former Congressman Amash's bill. And let me go ahead and just and read those. So Congress finds the following. 1, the Constitution authorizes and obligates each branch of the federal government to protect individual rights. 2, Congress is specifically authorized by the 14th Amendment to provide remedies for states' violations of individual rights secured by the Constitution. 3, the Constitution secures the rights of individuals whom the government seeks to punish for violating its laws. 4, the government's use in rem proceedings to forfeit property to punish legal violations without affording property owners the rights of criminal defendants plainly violates their constitutionally secured rights. 5, the government's use of a legal tool at the time of the founding does not preclude it from being incompatible with constitutionally secured rights. 6, the long-term failure of Congress, presidents, and the judiciary to recognize the illegitimacy of the government's civil forfeiture practices does not divest them of the authority to do so. And 7, the government cannot lawfully jettison the rights of the accused for the sake of convenience and profit. 8, the early use of civil forfeiture in the United States was limited to admiralty and revenue contexts, in which case the existence of a legal violation and the identity of the property used to effect it were often self-evident, and the owner of the property to be seized was often unattainable. 9, although the limitations on early civil asset forfeiture practices do not prevent those practices from being constitutionally infirm, they do materially distinguish the early practices from modern civil asset forfeiture. 10, the use of civil asset forfeiture by states is not limited to admiralty or revenue context. Its reach extends far beyond property used to commit an offense and is used often to supplement rather than recover the government's revenues. 11, civil asset forfeiture statutes and precedents incorporate certain protections for property owners that, although limited, erode the nature of the proceedings as truly in rem and betray the punitive nature of civil forfeiture. 12, the tortured status of civil forfeiture in current law, in which the fiction of the property as the defendant is sustained, yet the interests of property owners are, to a limited extent, nonetheless recognized, is the inevitable result of grandfathering civil forfeiture into a constitutional system that otherwise secures the rights of the accused. B, it is the sense of Congress that the Constitution authorizes and obligates Congress to prohibit the use of civil asset forfeiture by the states. So these findings remind us that there was civil asset forfeiture going back in America's history, that this is not a new process. Again, it was ramped up during the drug war. And so it would happen frequently in cases of like smuggling, where the smugglers might not stick around to establish their ownership of property. And so if you didn't know who was trying to bring things into the country illegally, the federal government was able to seize it and keep that property. But in the 21st century, we can do better. And so these findings lay out the process for restricting the state use of civil asset forfeiture. And let's see. So those are the findings that came from Congressman Amash's HR 899. They are not all included in the Blueprint for a Better America, but they establish the way that the justification for restricting the states. But this is what, share my screen here, this is what Section 120 does. It recognizes the sense of Congress that the Constitution authorizes and obligates Congress to prohibit the use of civil asset forfeiture by the states, and establishes these procedures. In general, property owned by a person may be forfeited to a state pursuant to a civil proceeding only after, 1, a criminal conviction. So again, starting with requiring that somebody actually have a criminal conviction before their property can be seized. So only after a criminal conviction or a civil proceeding in which the state proves that the person who owns the property has committed the offense and proves that they have committed the criminal behavior, and the person who owns the property gets all the protections that a criminal defendant would get, including a trial by jury and the ability to be represented by counsel. So in order for the states to use civil asset forfeiture, they would essentially have to go through the same process as obtaining a criminal conviction and provide all those same protections to the defendant. If states do not follow these rules, then this section creates a federal cause of action. A person who's been aggrieved by a violation of these subsections may bring a civil action against the state in the appropriate federal district court for relief including return of forfeited property and enforcement of the procedures described. And this would apply to forfeiture proceedings occurring or pending in or on after October 30th, 2022. Okay, where are we at here? Let's see. A few more statistics about how civil asset forfeiture is used. According to the Drug Policy Alliance, 80% of the time there are no criminal charges filed. Instead, the burden of proof is on the owner to demonstrate that the property is innocent. And there was an armored car company that filed suit because their vehicles had been stopped 5 times in the last year while they were transporting cash from legal marijuana dispensaries, and the police stopped them, didn't charge them with giving them any traffic tickets or anything, but seized more than $1 million in cash from those armored cars. This is a problem that is also solved by the blueprint, because those, by lifting the prohibition on marijuana dispensaries from using the banking system. So we're going to solve this problem in a couple of ways. One, by making it unnecessary for them to have armored cars moving cash around, and 2, ending the practice of civil asset forfeiture. And so where are we at? The Supreme Court. I also want to talk about the case of Tyson Timbs versus Indiana. And this was a case where back in 2019, the Supreme Court ruled that Timbs was a guy who had pled guilty to selling a few $100s worth of drugs, and then the state seized his $42,000 Land Rover. And he said, this is an excessive fine prohibited by the 8th Amendment. And the Supreme Court unanimously agreed that this amount of civil asset forfeiture was unconstitutional. And so let's see, a couple of the other states. There are 36 states, according to USA Today, and the District of Columbia, that have taken steps to scale back their civil asset forfeitures in the last 8 years. But in 46 states, it still exists. And North Carolina has abolished it, along with Nebraska, Maine, and New Mexico. And I want to close with one more story. This one's from February 2021, and a man named Stephen Lara. Now, he's a Marine. He served in Iraq and Afghanistan. He's a father. And sometimes when he travels, he takes his savings with him. Well, the Nevada Highway Patrol pulled him over for allegedly passing too close to a tanker truck. And I'll put a link to the video in the description below, so you can see the body cam footage of the police finding the money where Stephen told him it was, in the trunk. They found his life savings, the $87,000, with the bank receipts accounting for it, and then just deciding, well, let's just take the money and give it to the DEA. And so they did, not because they thought he'd committed any crime, but just because they could. They just convicting him and inconveniencing him and taking his stuff on mere suspicion without any evidence. And there's something pretty Orwellian about this process. And if you watch that video, you will see Stephen offering sympathy for the officers as they leave him on the side of the road with no money for gas, no money to buy his kids meals, no money for a hotel. And he tells them, I know you're just doing your job. You know, you're just doing your job. But if this is your job, to take people's money on the side of the road, your job is wrong. And if we're going to build a better America, we're going to stop this process. According to a June 2020 poll, 82% of Americans, we're going to have to stop this. Civil asset forfeiture is largely unpopular. People understand that it's wrong. And so by demanding that Congress enact the Blueprint for a Better America, we will end this process. I'll check that and see if we get any questions. And if not, we will move on to the next section. Okay. All right, section 122. This is a new section that was added during the year, during the subcommittee process, and it relates to the eligibility for the Byrne grant program. Now, as we've talked about, the Byrne grant program is the federal program where states get grant money for law enforcement and similar things. The Byrne grant program is named for a New York police officer who was killed while on a stakeout, and in his memory, they renamed the program after him. And so this is the way that, while the federal government can't necessarily tell states exactly what they have to do in most cases, we can encourage them, support them, use the power of the purse strings to influence them to adopt these rules. And so here's what we've got in section 122. Now, the reason that this works out this way, it has 5 different parts of the Blueprint for a Better America, some of which we've talked about and some of which we will in the next week. And the blueprint as introduced used an all or nothing in these cases and said, look, if states don't do this, then they lose all Byrne grants, all eligibility for Byrne grants. And there was concern that that could be counterproductive, that if this legislation asked the states to do 6 different things and they did 5 of them but not the 6th, that they would then lose everything. And so what was really the incentive for them to do those first 5 things? And so we came up with this this process of breaking down the eligibility based on certain criteria. And so part A here, the requirements for Byrne grant eligibility, they would be restricted unless these 5 things were done. And so number 1 here has an effect a law that prohibits the use of solitary confinement. We're going to talk about this, and this is a two-part process of restricting the extended uses of solitary confinements and then putting more due process in place. Number 2 is have an effect that a law that is consistent with section 115B, that was that is the Peace Act, that state law, having a state law training on de-escalation. Number 3 is a requirement that they undergo the training programs on the duty to intervene. Number 4 is the police misconduct registry, submitting the information to the Attorney General. We're going to talk about that in the next section. And then number 5 is the reducing cash bail. As we talked about yesterday, the blueprint ends the federal practice of reducing cash bail. And on the state level, what we would do is tie Byrne grants to the reduction of the use of cash bail. And so for the 2025 fiscal year, states would need to reduce the percentage of criminal cases where payment of money was a condition of pretrial release. In the previous year, they would need to reduce that to 75% by fiscal year 2026, 50%, then 25%, and for fiscal year 2028, 10%. So a series of reduced percentages going forward. And again, this is about breaking the all or nothing paradigm that we had in the first version of this legislative package. So if the state has only 4 out of 5, they can get a Byrne grant in these percentages. And so the percentage of the previous year's Byrne grant would be the maximum grant that they could get in a given fiscal year would be a percentage of the previous year. And you'd add up these percentages. So for the solitary confinement, 20%, for compliance with the Peace Act, 15%, for training on duty to intervene, 30%, for the police misconduct registry, 30%, and compliance with reducing cash bail, 15%. And you probably notice that these don't add up to 100%. They add up to 110%, because if you meet all five, then you've got 100%. You're eligible for 100% or more. There are no restrictions on your Byrne grant eligibility as a state. But if you only comply with five of them, you could get as much as 95% of your previous year's grant. The amount of grants in 2022 was $382 billion, and that's up almost 10% since 2020. So there's a lot of money that is being offered to the states, and by offering them an incentive to establish justice, to address these problems within their state laws in the coming years, then we can persuade the states to do these things. And so that is what section 122 would do. And I'll just check here for questions, and seeing no questions, we'll move on to section 131, establishing a national police misconduct registry. All right. Section 131, establishing a national police misconduct registry. This does pretty much exactly what it says, a national police misconduct registry. This would be a publicly searchable database, and it would be made available to the states and public. And here's the way that it would be broken down. The Attorney General would have until May 25th of 2023. You might recognize that date as the 3rd anniversary of the murder of George Floyd. And the database would have the following data points. It would have a record of the complaints filed against a law enforcement officer, aggregated by whether or not they were credible, or whether or not they were involved in the use of force, complaints that are pending review, and complaints for which the law enforcement officer was exonerated, or the complaints were determined to be unfounded, not sustained, so that there'd be a record of the public would be able to identify patterns in the complaints that were filed. Discipline records, termination records, records of certification in accordance with section 132, which we're going to talk about in just a second, and records of lawsuits against federal law enforcement officers and settlements of such lawsuits. Instances where a law enforcement officer resigns or retires while under active investigation related to the use of force. So if an officer, there's been a complaint filed, if they're under investigation for the use of force and they resign, that data would also be included in the federal misconduct registry. Now, the reporting requirements would require the head of federal law enforcement agencies to update this information at least every 6 months. And as far as the states goes, in order for the states to receive funding under the Byrne grant program, they would be required to keep this information updated with the registry. This would be publicly available, and initial funding for this program would come from reducing the drug czar's budget and using that as startup funding. So you'll notice that this is not one of the let me say, optional things that was listed in the previous section 122, that this would block the state from receiving any federal Byrne grants unless they kept their information up to date with the federal misconduct registry. So this is something that isn't optional, that this would be an important part of keeping the public informed about how members of law enforcement are performing in their duties. And this is not just for the benefit of the public, but for the states to utilize as well when hiring officers. There was the officer who shot and killed Tamir Rice, so a 12-year-old running around waving a toy gun in a Cleveland park. He had been let go from another police department, and that wasn't reported to the new department. And so that lack of information may have been a contributing factor into the death of this innocent 12-year-old. So by making this information more publicly available, we can reduce the problem where officers are let go or quit from certain jurisdictions because of problems, complaints, or whatever, and then go get hired somewhere else. So we can fix that problem. And all right, our last section tonight. Check. All right, seeing no questions. I'm going to look at section 132, and these are certification requirements for the hiring of law enforcement officers. Again, this is an all or nothing thing for the states, requiring that they only hire officers who have completed these certifications. Yeah, so the Attorney General will will establish rules with the interested parties, make up rules about how this section and the previous section work, the reporting requirements, and the record keeping requirements and things like that. And this will require that it will establish national training standards for the hiring of law enforcement. And the Attorney General also requires the Attorney General to share with all those law enforcement agencies the information that is obtained in the National Police Misconduct Registry. Go back up here. Yeah. All right. I think that covers everything in this section of the George Floyd Justice Act. And so tomorrow we're going to take a day, give ourselves a break from digging into the legislation, and instead focus on sort of the larger picture of how exactly the process of unionizing as voters works, some of the underpinnings, philosophical underpinnings of it, how it would work as a practical matter, the overall ways that the way that this would work, that we, the people of the United States, can change our political structure, because the one that we have now is not working, where Republicans and Democrats work to get us get American people riled up, to get Americans angry with each other, And they do this, by pointing fingers. The other party is the worst party. You got to vote for us. We're the lesser of two evils. And we've been trapped in this model of trying to pick the lesser of two evils. And there is a better way. The better way is, instead of being against something, is being for something, being for ending poverty, ending mass incarceration, and ending the endless wars. And the way that we do that is by unionizing as voters, by coming together with one set of legislative demands across all 470 congressional districts, and demanding that Congress enact this legislative package prior to the midterm elections. And they would become the most popular, most transformational Congress in generations if they got these things done, if they brought Americans together and said, yes, we are going to solve problems and not just kick the can down the road. America has the ability to do this. We can solve these problems. We can bring our country together. We can fix the political structure. But it will take courage for Congress to act. And that courage has to come from us, from we the people. And we can inspire them through our fast of moral pressure on October 15th. So if you want to build a better America, there is a better way. You can learn more on our website, anamericanunion.com, and join the general strike against Congress in 18 days and say, look, the way that we are doing things is not working. We, the people, demand better. Thanks for your time. I'll see everyone tomorrow evening.